Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5235. iTech US Inc., appellant versus Tracy Renaud, acting director, United States Citizenship and Immigration Services. Mr. Forney for the appellant, Mr. Goldsmith for the appellate.
Good morning, counsel. Mr. Forney, please proceed when you're ready.
Thank you, Your Honor. May it please the court. Jeffrey Forney for appellant, iTech US Inc. The court must start from the presumption that Congress intended judicial review of agency action. It's a long-standing presumption. It's embedded in the Administrative Procedure Act and has been long recognized by the Supreme Court. Absent clear and convincing evidence to the contrary based on the text and structure of the statute at issue, the court has jurisdiction to review the agency's action. That guideline defeats the government's claim that petition revocations under Section 1155 are not subject to judicial review. The overarching statute in question, which potentially, at least in the government's view, triggers the lack of judicial review, starts with Section 1252A2B2. That provision removes the court's jurisdiction to review any decision or action specified to be in the discretion of the Secretary of Homeland Security. But revocation decisions under Section 1155 do not come within the ambit of that provision because Section 1155 does not specify that revocation decisions are within the discretion of the Secretary of Homeland Security or his delegate, in this case, USCIS. Notably,
your theory has to be that specify imposes a magic words requirement.
No.
1155 is as discretionary can be. You have a may, you have an at any time, and you have for what he deems. That exudes discretion. The only thing you don't have is the D word. So what are you arguing? What could you be arguing for other than magic words?
Well, you don't need magic words, that's correct. But if you look at the statutory history and the structure of the statute, which is one of the guidelines that the Supreme Court says you need to do in cases like this where the government is arguing no judicial review, a companion provision regarding visa revocations under Section 1201I, which was enacted at the same time as the petition revocation provision. 1201I uses the word discretion and has always used that word. Those two provisions have been amended at the same time over the years, and Congress specifically buttressed the lack of judicial review in visa revocation cases, but never touched 1155 to indicate that petition revocations are discretionary. That absence of the word, I believe, in this context is very notable. And although Your Honor is right, magic words are not required, that statutory history and the structure is very indicative of congressional intent. They certainly know how to say when they want an agency decision to be immune from judicial review, and they just haven't done that specifically in the context of 1155. Now, regarding the other words that Your Honor pointed out that are in 1155, let's take them each in turn. For example, the phrase at any time doesn't in itself indicate discretion. It simply indicates that at least within a notable range that there's no statute of limitations. Other provisions in the statute have statute of limitations like revocations or a rescission of adjustment of status under a later provision. For example, Section 1256 has a 5-year statute of limitations, so Congress just simply indicated there wouldn't be in the ordinary course of statute of limitations on revocation.
With the other two pieces of it, that's at any time, but with may and with deem, those are both aspects of the statute that we pointed to in our decision in Zhu.
Mhm. Yeah, that's correct. Zoo's not controlling because, of course, unlike what the government wants the court to do and what they've asked other courts to do, is to parse words. The appellant's position is that you can take all these terms together, it still doesn't impute discretion. For example, in Zhu, the court read all of those terms together, deems to be in the national interest. So that word deems was significant in that context because, of course, national interest presents a spectrum of options that are not amenable to judicial review. In that case, in Zhu, it involved, of course, a second preference petition that was denied, but there were no judicially manageable standards because, again, in order to obtain a waiver in that context, the Secretary of Homeland Security has to find it's in the national interest. That's just not amenable to any judicial standard. There's nothing for the court to evaluate. And that followed from, as the court indicated, from Webster v. Doe, which involved a similar type of situation where the head of the CIA could determine the dismissal of employees for what he deemed to be in the national interest. And interestingly, in that case, in Webster v. Doe, that statute also said in the discretion of the director of the CIA. I think with both Webster v. Doe and this court's decision in Zhu, counsel is that statutory terms have to be taken together as a whole. You can't parse words and count them up and then say, in the end, we think there's discretion here. They have to be taken together. And the critical terms to be taken together with deems at any time in May is good and sufficient cause. That good and sufficient cause standard is specifically referencing, as the statute indicates in 1155, the standards under 1154, which have to do with petition adjudications. And that statute actually provides manageable standards. There has to be fact finding, and the facts have to fall within the particular visa classification that's at issue, and those standards are defined by 1153. So in order to find discretion in this case, without that term specifically being used, which it's not, the court would really have to ignore the import of good and sufficient cause. And I believe the Ninth Circuit...
But it seems like the word deems is doing some work here, because in Zhu, I understand your point that Zhu involved a statute that referred specifically to the national interest.
Sure.
Now, I mean, we could have a debate about whether national interest is more indicative of deference than good and sufficient cause. I don't know that there's a clear answer to that. But what Zhu emphasized was that the word deems preceded it. And that's why the parenthetical of Webster versus Doe highlights and italicizes the word deems. And that's what makes this seem awfully discretionary, is that it is what he deems to be good and sufficient cause. And that seems to give the person that's making the determination of good and sufficient cause a wide berth of discretion to make that determination, because it's whatever he deems.
Well, deems means judgment, a decision. If the statute just simply said he can revoke if he deems so, without any other reference to other statutory provisions or good and sufficient cause, I have to agree with you. It would be completely open-ended. There'd be no judicially manageable standards or discernible standards at all. But the fact that it's this good and sufficient cause means the judgment can't just be free-floating, disconnected.
But counsel, the statute could just say the secretary for good and sufficient cause may so-and-so, may revoke. And then perhaps your argument would be well taken. But I think the point of the prior question is that it doesn't say the secretary may for good and sufficient cause. It says deems, what he deems or she deems to be good and sufficient cause. And I think the point of the prior question is that in that context, deems has to do some work. Why isn't that the case?
Well, deems certainly does some work. The statute indicates that, of course, it's the Secretary of Homeland Security's decision. It's his or her judgment, as deems indicates. But that, again, that judgment can't be disconnected from any standards, because there has to be some baseline. What is good and sufficient cause? And then if deems is a free-floating term that controls everything else, it would apparently negate the reference to 1154 that's specifically noted in section 1155. So those standards just disappear because there's the word deems. The conclusion that the government wants the court to come to, and that unfortunately other courts have come to, except for the Ninth Circuit, is that you basically have to ignore any kind of import of good and sufficient cause. But at minimum, the fact that good and sufficient cause is there in the statute and there's a reference to 1154, at minimum creates an ambiguity. And with that ambiguity, there's no clear and convincing evidence that the court is stripped of jurisdiction.
Okay, let me make sure my colleagues don't have further questions for you at this time. We'll give you a bit of time for rebuttal, Mr. Forney. Thank you. Why don't we hear from the government, Mr. Goldsmith?
Your Honor, may it please the court, Aaron Goldsmith on behalf of the government. I'd like to begin by talking about the zoo decision that was just referenced a few minutes ago, because I want to clarify a point. There were two different statutes that were interpreted in that case, and there were, in effect, two different holdings. One of them is controlling here, and that is its interpretation, this court's interpretation of 1252A2B2. It specifically addressed the question of whether or not a provision needs to use the word discretion in order to fall within the scope of 1252A2B2. And this court said it does not need to use that word. Now, it then went on to interpret another provision involving the waiver, national interest waiver of labor, but that's a different provision that may not be controlling, although I think it does provide some guidance since it uses two of the same words that 1155 uses here. And not only was that this court's reading of 1252A2B2 in zoo, but the Supreme Court in Buchanan, footnote 13, read 1252A2B2 in the exact same way for this same reason. Now, I know that wasn't central to the Buchanan decision, but the clear import is that 1252A2B2 does not require the use of the word discretion in order for a provision to fall within its scope.
Can I ask, on 1252A2B2, if I said that right, yeah, 1252A2B2, can I ask the following question, which is, if the secretary denies a petition, that's reviewable. But then, right, but then if the secretary revokes a petition, the approval of a petition, it's not reviewable. And it just lends itself to the following situation potentially, which is that the secretary denies, and then there's judicial review, and the court sends it back and says the grounds for denial is erroneous. And the secretary says, okay, well then I'm granting, and then I'm turning around and revoking it for exactly the same reason.
I want to address that concern. Of course, the presumption of regularity cuts against that, but let's just assume your scenario.
Yeah.
There is a distinction between denials and revocations, and presumably when an agency says it's revoking something, it actually is revoking it. But under your scenario, I'm not sure that's true. If an agency were foolish enough to approve something and then immediately revoke it, it seems that that would be in substance basically a denial, not a revocation. That the law deals in substance and not in formalities and labels. It would be akin to an agency trying to, let's say, deny a petition and then writing at the top of the page, it's a revocation and claiming it falls within 1155. That wouldn't pass muster. The courts still look to see, is this in fact a revocation? You can't just get out of that by labeling it a different way.
I'm sorry, what's the difference between the two in this line of reasoning? Between a revocation and a denial?
Just the plain meaning of the words, if in the first instance it's a denial, it's made a decision. If it has in substance initially approved something. It's found that they meet the standards set forward by statute or regulation or AO decision, and then subsequently, as in here, they revoke it. And this was not like the hypothetical that was just posed to me, in that it was over 2.5 years later. So
but your answer to the hypothetical suggests that the revocation power, which on its face seems to be purely discretionary, might, for structural reasons, have limitations built into it. Right? You're saying something that looks like a revocation might actually be an improper denial.
I'm saying that the scenario that was outlined would never come up in practice. So it's a difficult hypothetical to address given the presumption of regularity. And the question was, well, but if it did come up, how would a court, how would it be handled? And I think that's how a court would look at it, would look at the substance of what it is. Now, I'm not sure that's necessarily the right answer, but I think that's how, as a practical matter, courts would look at it if that situation ever came up.
I mean, I guess one way to conceive of that kind of hypothetical is, correct me if I'm wrong, that whatever work that hypothetical would do on behalf of appellant's position, it would be equally true for even the granting of reliefs that are specified in Romanet 1. In that, if you could have the same dynamic play out under Romanet 1, if I'm thinking about it right. Maybe I'm not, but if I'm thinking about it right, you could have the same dynamic play out under Romanet 1, because there could be a judgment regarding the granting relief under one of the specified provisions, i.e. a denial of relief. A court would have judicial review of that. Oh no, the court wouldn't have judicial review to begin with. I see.
Right. Now, subsection 1 and 2 should be read in harmony. There is a difference that opposing counsel brought up, or was sort of alluded to, which is that for subsection 1, it uses the word judgment, whereas subsection 2 uses decision or action, which is presumably broader. So there is that a little bit of a difference there. Congress didn't define what judgment means, but it is presumably narrower than any other decision or action. So I'm not sure how that would exactly play out in your situation. But what I'm sorry.
So you still have that potential dynamic at play then with respect to this provision, because you could have the denial of a petition followed by judicial review that said the grounds for denial is wrong, followed by a revocation that is on the same ground on which the denial was deemed to be wrong. You could have that. Now, I'm not saying that necessarily means that your reading is wrong at the end of the day. It just seems like a feature of the judicial review provisions as you outline them, is that you could have that dynamic play out, and the result at the end of the day would be no judicial review, unless, as you say, a court would say, well, effectively, even though you're saying, you, the secretary, are saying it's a revocation, we are deeming it, to use a word, we're deeming it to be a denial in this context and substance, and therefore we're going to say it is reviewable as if it were a denial all along.
Your Honor, it is a difficult hypothetical to address, but I think how courts would address it if it ever came up is they would say it is in substance a denial. And just to move on about the Buchanan opinion, it just because it's been referred to a couple times. In footnote 13, it reads 1252 A2B2 the same way that this court did in Zoo, and there have been 4 circuit courts that have addressed this precise issue since Buchanan, and they've all come to the same conclusion that 1252 A2B2 bars judicial review of revocation decisions, that it is just the plain text. As the Seventh Circuit has said, it's hard to imagine a clearer grant of discretion than the language of 1155, and that this case is at heart a case about statutory construction, about what the words mean. And when you read these two provisions together, there's only one outcome, and that is that there is no judicial review of revocation decisions. And as a result, the decision of the district court dismissing this case.
Can I ask you one last question, at least for my purposes, I think, which is, are you aware of any other decision or action of the Attorney General that's specified to be within the discretion of the Attorney General or Secretary that would not be considered a judgment regarding granting of discretionary relief?
I'm sorry, I don't understand.
Okay, so let me lay the groundwork for this. So Romanet 1 deals with judgments regarding the granting of relief.
Right.
Romanet 2, what you've argued is it speaks more broadly than that because it talks about any other decision or action that's specified to be within the discretion. And then at the end of Romanet 2, it carves out the granting of relief under the asylum provision, which is also the granting of discretionary relief. Now, what the other side says is this whole thing, especially if you take into the title, is about denials of discretionary relief. But yet this decision, the one that's particularly at issue in this case, doesn't have to do with discretionary relief. And so you shouldn't read any other decision or action to go beyond discretionary relief. Your position is, well, if you look at the plain text of those terms, they're not limited to discretionary relief. They extend beyond that. And I guess my question is there any other provision that you're aware of in which this same dynamic comes into play, which is that it's true that it doesn't involve discretionary relief, but it's still a decision or action that's subject to discretion and therefore outside the bounds of judicial review?
Two-part answer. Just quickly, 1252 also has this word authority. So it's not just discretionary decisions or actions. It's if the authority to take that decision or action is specified to be in the discretion of the agency. Just to clarify that point. In terms of the point of the title, we've already addressed why we don't think the title is controlling, but we also note that 1252, the overall title of it, speaks of review of orders of removal. And yet, if you look at the text of 1252, it includes a number of types of situations that are not bound, that don't arise in the context of orders of removal. The overall title is Judicial Review of Orders of Removal, but the text expands that in other contexts. And that's why this is particularly not a persuasive clue as to the meaning of what Congress intended in this particular context. And I would also note that immigration law is different from some other areas of law in that sometimes Congress speaks to a particular subject with a comprehensive reform that is either not amended or amended once to address a particular loophole. But that's not how immigration law has developed. That's not how the INA has developed. It was drafted and enacted in 1952, and then it's been amended in a piecemeal manner. So there are the titles don't necessarily match up with all the text that's underneath the matter, and moreover, just generally. And I see my time has expired, so I'll wrap up on this thought. That titles, by their nature, tend to be summaries and therefore can be under-inclusive in that they don't address every term or condition or every qualifier.
Right. So let me just try one more time, and maybe I'm not articulating this correctly, but let's just suppose let's just assume for present purposes, I don't doubt anything you're saying about the persuasive force of a title. So I take the point on that. My question is just a practical one. For this provision that deals with revocations under 1155, the government's argument that it's immune from judicial review is that it's a decision or action of the, and then go on under Romanet 2. And the other side says, well, wait a minute, this whole provision is about discretionary relief. This particular decision or action doesn't have anything to do with discretionary relief. And my only question is there any other example of a situation that you're aware of as a government in which you would say this too, like an 1155 revocation, is a decision or action the authority for which is specified to be within the secretary's discretion, and therefore immune from judicial review, even though it doesn't involve the grant or denial of discretionary relief. It may not be, it just may be that there isn't any other one. I'm just curious to know whether you're aware of any other decision or action that brings this issue into play.
The one partial answer I can come up by is, and if you look at, and it appears in subsection 1, it's 1255 is adjustment of status, the granting of a green card. Certainly there's discretion involved, but would we describe, and I agree that a green card is a benefit. In everyday language, we wouldn't call that necessarily relief. And that's not necessarily the word we can. So that's a partial example, although not. I can't think of another one at this moment, Your Honor.
Okay.
Just one more question from me, which is probably a variation on the theme of the Chief Judge's first question, which is, on your reading of the statutes, there's a very odd disconnect between the standards on the front end for the eligibility determination, which are objective and mandatory, and what you say is the wholly open-ended, unbounded discretion to revoke. So let's say, assume hypothetically the statute, the eligibility determination, instead of saying advanced degrees, let's say it said college degrees. And assume the secretary grants a visa and then revokes it. And he says, I'm revoking this because you have a college degree, but I don't think that's good enough. I want an advanced degree. Mm-hmm. Would that be lawful?
Your Honor, it might not be lawful, but it also might not be reviewable in district court, because the agency has come up with an administrative remedy for that. That is, the remedy by regulation they've come up with is an appeal to the Administrative Appeals Office. I recognize your larger point. Sorry.
In other words, so I guess where I'm going with this textually is another possible reading of 1155 is to say good and sufficient cause doesn't just mean anything the secretary thinks, which would be a plausible reading if you just had 1155 by itself. But if you construe 1155 together with 1153, good and sufficient cause might mean the secretary thinks there's a changed circumstance or the original adjudication was wrong, but he still has to measure the revocation against the substantive, judicially manageable, mandatory standards of 1153.
I think addressing your larger point is, I recognize that an agency is not always right, that agencies do make mistakes. I get your point on that, but Congress made a policy choice, whether it was a good policy choice or not, to make certain decisions not reviewable. And 1252A2B2 applies to some set of decisions or actions. We can disagree as to which ones, but for the reasons we set forward, we think that 1155 falls within the scope of that. Obviously, there's always this argument that an agency is not correctly interpreting the statute or regulations or whatnot, but that isn't enough to overcome a bar of judicial review when Congress has spoken to it clearly, and this court has already found that 1252A2B2 is such a bar.
Okay, let me make sure my colleagues don't have additional questions for you, Mr. Goldsmith. Thank you.
Thank you.
Mr. Forney, we'll give you 2 minutes for your rebuttal.
Thank you, Your Honor. Let me just address the two hypotheticals that Your Honor has put forward. The first hypothetical about immediate revocation after a remand from a court or a court indicating that the initial approval denial was incorrect. It's just a type of absurd situation that is actually permitted by allowing complete impunity with the Secretary of Homeland Security and not allowing for judicial review in this context. And the response that my learned opposing counsel made, I think, punctuates that point, because if they just simply revoke and say, okay, well, fine, our denial was wrong, we'll approve it, and now we'll immediately turn around and revoke. His response doesn't make much sense, because the government would actually argue that, no, it's a revocation. You can't look beyond the face of the documents. Revocation falls within 1155, no review. This is exactly the reason why there is a presumption of judicial review, to avoid this type of administrative caprice. And then I think a point that's been missed, and I do want to emphasize this, it's in our briefs, but I don't want to make sure it's lost, is that the Board of Immigration Appeals has historically viewed 1155 as importing substantive standards from 1154 and 1153 that govern petition adjudications. And some courts have dismissed that by saying, well, it doesn't matter because Congress apparently didn't know of the BIA's decision. I think that misses the larger point, because Congress specifically said by statute that the Attorney General's decisions of law are controlling. The Attorney General's delegate in this case has had a longstanding interpretation to import judicial standards, substantive standards into 1155. And that point cannot be missed. It has to be incorporated in there. That's what Congress wanted.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you, Your Honor.
Case number 20-1075 et al. Arapahoe County Public Airport Authority et al. Petitioners versus Federal Aviation Administration and Stephen Dixon in his capacity as Administrator of the Federal Aviation Administration. Ms. Bruch for the petitioners, Ms. Katsas for the respondents.
Good morning, counsel. Ms. Bruch, please proceed when you're ready.
Thank you, Your Honor. Good morning, and may it please the court. My name is Kimberly Bruch, and I represent the Arapahoe County Public Airport Authority, and I'm also arguing on behalf of the other petitioners in this matter. In 2020, the FAA changed decades of flight patterns in the Denver metro area by moving flight tracks over areas which have never experienced such activity before as part of the overall redesign known as the Denver Metroplex. Prior to the Metroplex redesign, the arrival procedures for aircraft into Centennial Airport originated from the Northeast. In particular, the new Bronco arrival procedure, which we outlined in our briefs, shifts the air traffic from the Northeast to areas further north and then west of the airport. This approach also requires lower altitudes than have been historically utilized by the prior Northeast approach. So overall, the new Bronco route is the Northeast arrival procedure, but requires aircraft to fly northwest of the Denver area. The relocation of these flight paths means that portions of the Denver metro area that have never been subject to regular flights now routinely experience them. And this gives rise to the environmental concerns raised, including noise, emissions, and the safety concerns by the petitioners. Now, contrary to some of the suggestions made, we're not suggesting that the redesign itself created an increase in the number of flights or operations over the metro area. What it did is it changed the concentration of the flights. So that's why there are references to increased flight traffic throughout the briefing in this matter. So when you're looking at examining cumulative impact, it's the change in the concentration of the flights, not an increase in the number of operations that's important.
Your principal client runs an airport, or is the airport in Arapahoe County, correct?
Yes, Your Honor.
what's the evidence that noise will increase in Arapahoe County? Either, I mean, you didn't submit any affidavits on standing. So what's the evidence in the record on that?
So in the record, each of the petitioners extensively participated in the public workshop and comment process. So the affidavits weren't necessary because the written submissions by each of the petitioners that we have cited in the briefs outline the concerns and were submitted to the FAA directly. They outline the noise concerns based on the relocation of the flight patterns.
But the agency found that this would affect something like 70 people in the whole state, and they're in Elbert and Jefferson County, which is not Arapahoe County.
Yeah, I think that the finding based on those small numbers of people was based on the evaluation based on an increase in the noise level, not the relocation of the flight patterns that changes the noise levels from one area to another. So it's a different analysis.
Sorry, you lost me on that. You're claiming, as I understand it, you can't claim a parens patriae injury. So now you're claiming a proprietary injury as a listener. It's someone who's going to be subject to increased noise, correct?
Yes.
So just walk me through the distinction you just made again in terms of listeners. I didn't get it.
Sure. So when you're changing the entirety of the route, I think the noise analysis that was conducted that identifies those small numbers of individuals that the FAA believes would be affected is based on an analysis of whether there would be an increase in noise over those locations. It's different than looking at the fact that you're now relocating flight routes to where there has never been a noise concern before. So it's taking it from, as the one example that we've kind of relied on, the Bronco route, when you're moving the entire flight path from a northeast direction, where those residents, if you do a noise analysis, you may find that using the same flight routes, there's no increase in noise based on the redesign. But when you take those flights and you move them to an area that has never had a flight route over top of it, it's not an increase in the noise. It's the fact that you've now picked up and placed that route on top of an area that has experienced no noise before. And so in particular—
But that's an increase from zero, no?
Yeah, yes. Which is different than the analysis that was conducted to identify those small numbers of people, which was to determine if an existing route would increase based on the level of noise.
Okay.
And so, at one point, the FAA actually suggested that the noise complaints are best handled by the local airport in the EA. So they put the onus on Centennial Airport to deal with these new noise issues, but then argue that we don't have, the standing or the ability to challenge the redesign, which creates those noise complaints that they're tasking us to handle. So I think there's also a direct link based on the FAA's own instructions related to how to deal with the increased noise situation that's created by the redesign.
Can I ask you on historical preservation, and staying on standing for a minute, your opening brief doesn't mention it at all under standing.
I'm sorry, which aspect, Your Honor?
Just anything about historical, with Gilpin County and historical preservation, it's just not mentioned.
I see. I think Gilpin County, at least initially in their docketing statement, mentioned their standing. And then I do believe in the opening brief, they argued that they had standing because the change in the area of protected interest was originally identified to include them. Then it was revised to exclude them prior to the release of the final EA based on originally, I think, a finding that they weren't going to experience any of the routes that were under the redesign. I think the issue that they raised in the opening brief was that once they moved what they refer to, I believe, as the Zimmer route, that put them directly under one of the new flight paths, but the area of interest was never revised then again to include Gilpin County. And so it was based on that procedural error that they originally relied upon for their standing.
And that's in the opening brief? And then you mean in the argument section, that the argument about Gilpin County should be taken
I think that's where Gilpin raised their issue with respect to standing, but they did include it in the opening brief.
Okay.
Just one more question on the geography. I'm just looking at a map. You said the basic import of this was to take a northeast flight path and move it to the north and to the west. We're just looking at the map. Centennial Airport is a good bit to the southwest of DIA. It's just hard to imagine that a northwest approach would have any impact whatsoever on that airport.
It's not the flights that are going into DIA, Your Honor. These are flights primarily that are on the approach route, the Bronco route that is one of the primary concerns. And just to be clear, the redesign encompasses a much broader redesign of the flight routes really than some of the concerns, that are specific to the petitioners. So we're talking about a subset of the overall. So the Bronco route in particular and the Zimmer route that is referenced by Gilpin County are approach routes into Centennial Airport. So they're not necessarily the flight routes that are utilized by DIA, although those are part of the overall redesign. The route that goes extremely far to the north is one of the approach routes into Centennial. So they take you way up north of the metro area. Then you have to cut west over to the foothills, which I think it shows on the Bronco map. Then you come south again and have to take a pretty significant left turn at that point to come into the airport. And that's where you drop down to then leave the Bronco route and do your approach into Centennial.
Okay.
Make sure my colleagues don't have additional questions for you at this time, Ms. Bruges.
Thank you.
Not, we'll hear from the government. Ms. Katsas.
Thank you. Good morning, and may it please the court. My name is Anna Katsas, and I'm arguing on behalf of respondents, Federal Aviation Administration, and Stephen Dixon. If I could, Your Honors, I would like to begin with the standing issue. Of course, this court must assure itself of its jurisdiction in order to review FAA's order. And in this case, the petition should be denied because petitioners have not established their standing to sue. It is not self-evident. They chose not to submit any affidavits, and they failed to establish each element of standing by evidence as required in their opening brief. And in particular, petitioners have not established an adequate injury in fact to pursue either their NEPA or their NHPA claims, which are the only claims that are raised in their brief. And in Florida Audubon Society, Your Honors, this court en banc made very clear that to demonstrate an injury in fact for a NEPA claim, a plaintiff must show that the omission or insufficiency of an EIS may cause the agency to overlook the creation of a demonstrable risk not previously measurable, or the demonstrable increase of an existing risk of serious environmental impacts that imperil appellant's particularized interest. They have not done this. And if I could take a moment to step back and explain what this project is. The Denver Metroplex project replaced 44 total arrival and departure procedures in the Denver Metroplex area with more technologically advanced, newer procedures. Now, these procedures are in existing flight paths, and there are numerous maps and diagrams in the record that show these are in the areas of previously existing flight paths. And
some of these are into and out of Centennial as well as DIA?
Yes, that's correct, Your Honor.
Okay.
That's correct, Your Honor. And the noise analysis, I would also like to take a moment to explain, because it's explained in the record at JA Joint Appendix 306. The noise analysis was conducted from ground elevation to 10,000 feet above ground level throughout the general study area, which encompassed more than 40% of Colorado's landmass. Now, the way that this was performed was that DNLs were calculated. The average annualized day-night sound level, which is the metric that FAA consistently uses and that this court has previously upheld, were calculated at 1/2 nautical mile intervals throughout this area. And they were also calculated at additional special points, such as where there were specific cultural resources. And Judge Katsas, as you mentioned, this only demonstrated that 71 people in 2009 and 121 people in 2014 would experience even a reportable noise increase from what they experienced if these procedures were not implemented at all. So it is not the case that FAA failed to evaluate certain changes, or it evaluated it throughout this area. And petitioners have not demonstrated any injury in fact to any petitioner, again, just to pursue either the NEPA or the NHPA claims. In their opening brief, so 4 of the petitioners are municipalities, and in their opening brief, they appeared to rely mostly on a parens patriae theory. Mountain aviation, they were presenting safety concerns, but they've not raised a safety challenge, which leaves Centennial Airport, the airport authority, which has asserted a proprietary interest. And they've mentioned the noise compatibility program, but they haven't established that this project will have any serious increased risk of environmental harm, much less that threatens to imperil the airport authority's proprietary interest in any way. So in this case, there really has been a failure to demonstrate that there is standing for this court to consider the claim. Ms. Bruch mentioned that these petitioners had participated in the process, but certainly that doesn't suffice to establish the requisite injury in fact. And while this is also a procedural claim, it is very clear that the injury in fact requirement is a hard floor that petitioners and plaintiffs must meet in every case. It simply has not been established in this case. In the reply brief, they mentioned for the first time that the municipalities suffered harm to government-owned property, but they haven't specified a single harm to a single specific property. And again, their obligation was to demonstrate this by evidence in the opening brief. And this made its first appearance in the reply brief. So on this record, it definitely is not self-evident, respectfully, Your Honors, and petitioners have not established it. I'll turn briefly to the NEPA analysis, and also to mention this project was developed over the course of 5 years. The Federal Aviation Administration began looking at this project in 2014. There was a lengthy study phase and then a design and implementation phase where safety was the paramount concern. During that time, over the course of 3 years, FAA held 42 public briefings and meetings and it developed these procedures. And then after that, it had a very lengthy NEPA process. FAA took comment not only on the draft EA, but also on the final EA. And there are thousands of pages in the record in which FAA accepted and responded to comments. So petitioners had every opportunity to raise their concerns. They disagree, they don't like some of the procedures, but FAA did a very lengthy process here, and it addressed all of the environmental resource categories that it consistently addresses pursuant to its order, 1050.1F, and petitioners have fly-spec'd this EA, but they have not identified any environmental impact that FAA overlooked, nor have they demonstrated that any element of FAA's analysis was arbitrary or capricious in any respect. Also, with respect to Gilpin County, Your Honor, Judge Srinivasan, you are correct. They did not address standing at all in the brief. It's mentioned, only in the merits portion of the brief. And as a correction, the Zimmer flight route does not fly over Gilpin County. It is north of Gilpin County. But the National Historic Preservation Act regulations establish a very clear process for compliance. And in this case, as we've explained in our brief, FAA followed that process to the letter. It reached out to the State Historic Preservation Officer very early in the process. It also obtained the preservation officer's agreement on delineating the area of potential effects according to where its noise analysis showed not only a significant, but also a reportable noise increase, which is in fact a very small area.
Can I just ask oops, I hear a little feedback. I hope nobody else is hearing that. Can I just ask on Gilpin County on the standing part? Their opening brief does say on page 46 in connection with the merits that Gilpin County is adversely affected and impacted by the Denver Metroplex project, and then goes on to make some arguments to that effect. Is that not tantamount to arguing injury?
I think, Your Honor, it's an argument, but it's not evidence as required. And it's not, the fact that they essentially say that we have historic resources, but that doesn't demonstrate that there's any actual, again, you need some increased risk of harm, some demonstration of some increased risk of harm to those resources. And they have essentially just said that there are resources here. So we submit respectfully, they have not met their burden on that point either. But also on that point, Your Honor, it's very clear that FAA was not required to consult with Gilpin County. Briefly, the Historic Preservation Officer provided FAA with a list of counties and municipalities that had historic preservation ordinances, and FAA consulted with the counties on that list that fell within the area of potential effects. So FAA worked with the Historic Preservation Officer. At the end of that process, FAA determined that the project would have no adverse effect on any historic property. The preservation officer concurred in that, and that fulfilled FAA's obligations under the regulations. If there are no further questions, Your Honor, we submit that the petition should be dismissed for lack of standing, or in the alternative, denied on the merits.
Thank you, Ms. Katsas. Ms. Bruch, we'll give you 2 minutes for your rebuttal.
Thank you, Your Honor. I think that part of the issue here is that the petitioners overall, all the municipalities, including Gilpin, had the right to comment on the documents. I think that's undisputed under Section 4332. And so it's reasonable then that those interests should extend to challenging the document on top of all of the other standing issues that the various municipalities raised. As I mentioned before, the airport has sort of been tasked with dealing with the increased noise complaints that are going to be the result of the Metroplex redesign, specifically from the FAA. That was their directive, that's how those should be handled. And so they have a direct interest, and as the FAA sort of conceded, a proprietary interest in managing the airport on that basis. If the standing is going to be so constrained, then the agency becomes insulated from judicial review, even where the actions strain the scope of the regulatory authority. Here, the not only the noise issues, but the increased fuel burn and the emissions that were raised by the airport, and these were all issues that were raised with the FAA before the EA was finalized. The FAA relies upon these public meetings and things, but the flaw here is that the municipalities and the airport in particular tried to participate in this process, tried to engage the FAA to try to raise these concerns practically and deal with these redesigned flight routes ahead of time so that we could avoid these issues, and they were essentially rebuffed. So even though they went through the motions of these public outreach actions, they really did not engage in the process. And so we do believe we have the standing, Your Honor, to challenge these. Thank you for your time.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
This honorable court is now adjourned until Friday, May 7th at 9:30 a.m.